Good morning, ladies and gentlemen. Yes, the virus was first identified in this country in 1984, and I was then practicing law in Nairobi. The first thing that I did was to write and say, let us jail everybody who is found to be living with HIV and AIDS. That was my first reaction. And I was cartooned in the Nation sometime in September 1984. Prominent advocates the jailing of people with HIV and AIDS. I have since, of course, taken this 180 degrees or 360 degrees, and I'm now on the side of those living with HIV and AIDS. I also want us to take seriously what Alan has just said about infecting lawyers. That has been my duty from 1984 up to now. I don't want to brag about it, but I think practically every lawyer who has been dealing with HIV and AIDS issues, we have associated together. I have learned from them, and they have learned from me. All I have done is to encourage them against any stigmatization that they have faced as a result of being advocates in this important field. Now, the formal things I want to say first is that the legal framework for the establishment of the HIV and AIDS Tribunal was actually laid in 2006. In the year 2006, with the enactment of the HIV and AIDS Prevention and Control Act of that year. We have had a very rough ride to the enactment of that law, starting from was the very first reactions in the 1980s, then the development of policy, the declaration of HIV and AIDS as a disaster in 1999, the establishment of a task force to look into the HIV and AIDS law, the filing of that report with the AG in 2002, and then the taking of the matter to Parliament. Parliament then enacted this law in 2006, but it was never operationalized until 2009. And more shockingly is that despite the establishment of the framework for the establishment of the tribunal, we were not appointed, or the tribunal members were not appointed, I think, until the year 2012. So you explain yourself what has been happening. Has there been resistance? And I want to say yes, there was a lot of resistance to the establishment of the tribunal, but I'm happy that I was the first chairman of the HIV and AIDS Tribunal. There were 9 of us, 9 members, I think so. Usually we had a quorum of 5. So I've just talked about the establishment and the framework and the difficulties we had in getting the tribunal working. It was part of the multi-sectoral response that was identified as the best way of responding in the National AIDS the policy session of paper that was adopted by Parliament in 1997 as a way of a multi-sectoral approach. Every sector was responding, and the response of the legal sector included provision of some judicial or half-judicial, in law we call it quasi-judicial process, and this was the HIV and AIDS Tribunal. Before I talk about its work, there has been a criticism. Whenever we go to international conferences, Kenya is criticized that we are actually stigmatizing people with HIV by having a specialized tribunal for people living with HIV. While we are saying that it's a good forum for addressing specialized matters that Alan has identified, in the fora, and I think I mentioned specifically sometimes in 2012, I traveled to Norway on a workshop that was dealing with various responses. And the position of most people in the room was that you should not have a specialized tribunal to deal with HIV because it is in itself discriminatory. That was an argument which you need to ponder over. I made good defense, a very spirited defense of trying to deal with issues, and I told them that we were dealing with these issues in camera. Now let me talk about the challenges that we had in the establishment of this tribunal. First, we had nowhere to sit. There was no court, there was no courtroom, and throughout my term, the tribunal sittings were held in my offices. That was the first major challenge. I'm now happy that there is at least a place that the tribunal is able to sit at. We had no room to use, and it took a long time even for that to be addressed. Number two, there was lack of capacity. We had no proper registry. As it were, some skeleton staff, I think of about 3 people, were sitting in the Prime Minister's office or something like that in town. As members of the tribunal, we had no training. In other words, it was a mixture of many people. We had medical practitioners, we had people from the NGO world, we had lawyers, but we had never sat together to be trained in the execution of what was expected of us. We just started and invented our own way of survival. So number 2 was that lack of capacity. Number 3, of course, was lack of public awareness. See, unless the consumers know that there is a tribunal that can deal with these specialized cases, then you actually have nobody. We have very, very few cases of people who knew about the existence of the tribunal. And we had to undertake an awareness campaign through the provinces, now the various counties now, to be able to tell them that there is something called an HIV and AIDS tribunal, because they didn't know how it operated. So that was our third challenge, the lack of public awareness of the existence of the tribunal, and particularly that it was dealing with these particular cases. And we also had this fourth problem, that because the proposed consumers, that is, people who would come and have their cases profiled, was themselves scared of the stigma. As you know, there's been a lot of difficulties in giving your police station to report anything that will be able to identify you as a person living with HIV. That discrimination. So we also suffered that. The fifth problem was lack of regulations. The act was there, but there were no regulations. So how are we going to operate? Or are we going to operate using the civil procedure, the civil process that we have in court? Or are we going to do things like cross-examination of people? Was it going to be something adversarial, or was it going to be inquisitorial, that you just make some kind of inquiry, or what? So we were wading, swimming in some deep end, not knowing even how we are going to go, for lack of regulations, because the Act just said regulations will be made, but there were none when we started, and therefore we had to invent our own procedure. We had to invent our own manner of taking evidence. We had to get our own manner of putting judgment. Even the filing of a case, the issue was, how does anybody file a case? Do you file the usual court papers that we know, or do you write a letter? So in our experience, we made it so informal and saying, you could even write to us, just write a letter. You pay no fees, so no fees were being paid, but you wrote a letter to us and we took up the matter. We opened the file and invited people to come. But as I said, they came with a lot of reluctance. So those, and of course, many other challenges that I would have gone on and on and on forever were my very first experiences as the first chairman of the HIV and AIDS Tribunal. In conclusion, I just wanted to say talk about one thing that has remained contentious. It was contentious even when we were drafting the law. I didn't say I participated in the drafting of the Act itself. The contentious thing is Section 24. And I would like the lawyers and the other activists and other people who are concerned. Section 24 of the HIV and AIDS Prevention and Control Act still remains to us a policy issue if we are talking about reform. Because in my view, it criminalizes HIV infection. We had arguments, and I know some drafters who are with me are in this room, And there was a big division as to whether we should include that. Public opinion, I think, influenced those who voted for the inclusion of Section 24. But I still argue that it must be repealed. Because, as I don't know what Mr. Arrow, my successor, is going to say, when I was there, people attempted to bring criminal cases. And Alan has just talked about criminal jurisdiction, the power of the tribunal to prosecute, to have people prosecuted before it. That really we must do away with, because I think it is counterproductive. It drives people underground, people who would otherwise come out for testing and early prophylactic treatment. Just go underground when they fear that we are going to be prosecuted. And so we must make conscious efforts to repeal Section 24 of the HIV Act. I'm grateful that you have had time to listen to me.